The final case for oral argument is Messer versus Arthur Rutenberg Homes Incorporated in Alton.
Good morning to each of you. If you all are ready to proceed, counsel for appellant may proceed. How long would you like to rebuttal?
5 minutes, Your Honor.
All right. You may proceed when you're ready.
Morning, Your Honor. May please support. My name is Kareem Mosasina. I represent the appellants Audrey and Alan Messer. I'm here as well with my co-counsel, Mike Denisha Mentor III. Providing a little bit of preliminary background on this matter, this case concerns personal injuries upon sustained in your new residential property as a result of an inherently dangerous condition. This inherently dangerous condition was a scuttle that was built in the garage of your new residential home, which should have never been constructed in the first place since it was noticeably omitted in the finalized home plans for the project. Nonetheless, the scuttle hole was a hole in the ceiling of the garage that provided direct access from the garage to this attic space directly above it. Underneath the scuttle hole was a plywood floorboard covering that sealed up the hole and gave the visual impression from the height of the attic that it was load-bearing, meaning that it gave the appearance that if someone was to walk on it, it would stand firm and allow the person to comfortably navigate the attic.
Well, Counsel, we're here as I understand it, we're not here about hearing aids, correct?
Correct, but I believe it's necessary.
Let me finish. Thank you for letting me finish. We are here about actual aids, correct?
Correct.
So the whole issue in front of us today is whether there was an actual agency relationship between ARH and Country Club.
Correct, Your Honor.
And as this judge understands components of actual agency and acknowledgement and acceptance and control. So how was there an acknowledgement in this case?
Sure. So in terms of the acknowledgement, we cited the argument in reply to the Philadelphia indemnity case, which concerned a rental company and an insurance company, where they had an agreement where the rental company would propose insurance policies to its clientele. The court there found this was a Middle District of Florida decision. The court found that the first element of actual agency of acknowledgement was meant by the authorization of the insurance company of allowing the rental company to issue out these policies. And in this case, to analogize, we have a franchise agreement between Country Club Homes of Florida Incorporated, the franchisee residential home builder in Flagler County, and Arthur Rutenberg, the appellee in this matter, the franchisor, that explicitly stated that as a Country Club, the franchisee was to be the exclusive residential home builder in Flagler County. That was analogous to it being, it's analogous to an acknowledgement by the principal as the agent's activity.
Well, and the cases are leading, counsel, starting with Mobile Wall, but Legion, that it's not enough to have a franchise agreement. You agree? That in and of itself is not a good enough.
For
the acknowledgement. I mean, that's not enough. I mean, the principal's acknowledgement that the agent will act for the principal. I mean, that's component one of this algorithm analysis. So a franchise agreement in and of itself is not enough. What here takes us out of that line of cases?
Sure. Although, as a fundamental prefatory point, the franchise agreement is extremely pervasive and much more stringent and limiting than a lot of the cases out there. That's a preliminary matter. However, in terms of the actual facts on the record, it is abundantly clear that Country Club was a franchisee for over 7 years by the time the Pones residence or the construction contract for Pones residence was executed. There is abundant evidence that subcontractors are worked apart for Rutenberg licensed properties, built homes to specifications above and beyond the Florida building codes, which was directly required by the franchise agreement. That is provided by the deposition testimony of 2 subcontractors in particular. There is also evidence that from the neighbor, Mr. Taylor, of the appellants, that Country Club maintained an office in believe it was Palm Coast, where the advertising said Arthur Rutherford specifically, not Country Club. And again, with regards to the opponent's contract in disputes, we're dealing with a contract that had the trademarks and logos of Arthur Rutherford itself. There's evidence in terms of purchase orders that are not only bear the trademarks of Arthur Rutherford, but also provide limitations in terms of the vendors that it can use. Specifically, one purchase order that is cited in the record states that Arthur Rutherford explicitly prevents the use of Chinese drawbell in construction.
What do you do with the document between ARH and Country Club owns the franchise and license agreement, where they delineate as to the relationship of the parties that in all matters pertaining to its operation, the franchisee Country Club owns shall remain to be an independent contractor.
And as stated by his court in the fund decision, I believe in 2003, it is not the terms used by the country, by the contracting parties, that determine the existence of an agency relation. It's the totality of circumstances that determine it. Just because a contract says there's a contract relationship, but it's not defined, that it's not dispositive. It has to be a case-by-case analysis of the actual facts and how the parties conduct themselves in the course of business.
Well, is that not part of the analysis of what the franchisor and the franchisee agreed to? Is that not part of what the court evaluates in determining whether there was an acknowledgement and an acceptance?
Certainly, Your Honor. It's definitely evidence of potential intent by the contracting parties. However, we believe that when reading the franchise agreement closely, it does seem pervasive to the extent in which it seems more akin to an employer-employee relationship. And just turning to the franchise agreement as a preface, this agreement encompasses several documents. The first preliminary franchise agreement that was executed by the owners of Country Club, Mr. Goff and Mr. Kimberly. There was an assignment agreement that was signed simultaneously that transferred the liability responsible to Country Club proper as the entity. And then there's also 3 addendums, as well as other ancillary documents, such as a construction manual, that were all part of plaintiff's Fourth Amendment complaint in the trial proceeding.
And is there any evidence in this record that any employee of ARH worked on this house?
No, Your Honor, but a pertinent inquiry in this decision, since this is a summary judgment and we're going to de novo review, is whether there was a right of control by the franchisor or in the construction of those residences.
So back to my question, the answer to that is no. There is no evidence in this record that any ARH employee worked on this house.
There were no roots to the ground in the actual property. However, we would note that the deposition of Alan Messer clarified that he met with the president of Arthur Rutherford and an architect to specifically design custom home plans for me.
And I read that. My question goes to the construction. And so no ARH employees worked on the house, correct?
Correct, as far as the record is.
And no ARH employees supervised directly on the site, the building.
As far as the record shows, correct.
And ARH is not a licensed contractor in Florida.
That is my understanding.
So even had they wanted to, they were not even licensed to work on this home, correct?
I cannot say for certain because nonetheless, the parties operated for over 7 years with strict contingents that allowed Arthur Rutherford to inspect at any point the residential properties. They had mandatory requirements as to the amount of homes that had to be built by the franchisee, the hours of operation that these facilities have to be run by. They even set the particular holidays that they apply to the workers, which seems directly representative of evidence of actual control of the day-to-day operations of the franchisee, which is perfectly clear.
Is there any evidence in this record, back to what you just said, anywhere that an ARH employee went to the site and inspected the building of the site?
No, Your Honor. However, again, the permanent inquiry as set by this court's bond decision is whether there is the right of control. And to just return to the franchise agreement in particular, if you were to look at the assignment contract specifically, it sets several requirements. Paragraph 5 of the assignment stated that Country Club, the franchisee, was not to transfer in any way, make any change with regards to its stocks without the prior consent of Arthur Rutherford. Paragraph 7 further stated that it was to have no business association with any other entities without the prior consent of the franchisor. And paragraph 8 of the assignment also stated that Country Club was to have no business activities whatsoever aside from its responsibilities and obligations under the franchise agreement. And in return to the primary franchise agreement itself, it states that they were to be the residential home builder for the franchisor in Flagler County. It says stringent requirements as to advertising. It says stringent requirements as to forms that were to be used, including the construction contracts, including the forms of purchasing order and disbursement reports. There was limitations as to hiring, in the sense that the franchisee could not hire from other franchisees.
And I'm sorry to interrupt you, but a lot of these things that you're listing, are those not represented in nearly every, if not every, franchise agreement? Isn't that part of it? You're selling the brand. So if you're not controlling some of those things and not indicating to the parties how they're supposed to do things, is it not a franchise? Where does that line end and the next begin with the right to control?
Correct. And so the law, as stated by the Mobile Florida Supreme Court decision, is that there has to be a substantial right of control by the franchisor, such that it extends beyond the mere use of trademarks, logos, and the mere contractual provision of franchise support activities. And when looking at some of the decisions cited by appellees' briefs, such as the Ferreira Court DCA decision or the Ortega Court DCA decision, in those cases, summary judgment was decided in favor of the franchisor, where they stated, for example, that there was no evidence that there was any supervision of the employees, where there was no control over the finances or the stock profiles of the particular franchisees. There was no stringent requirements as to hiring practices, whereas in this case, you again not only have an assignment contract that limits the transfer of stocks by the franchisee, but you also have mandatory training requirements in the franchise agreement for executives, officers of the company. And one point I haven't mentioned yet, what I believe is the most important and crucial, is the franchise agreement prescribes that the franchisor can appoint a building company president with the responsibility of overseeing the management and operation of the franchisee. That's directly related to the day-to-day operations of the franchisee. And specifically, this provision of the contract states that the building company president can be removed at will by the franchisor, with the only limitation being that they have to provide prior notice. And since again we're on summary judgment, we simply have to demonstrate a genuine dispute to material facts. Provisions such as these seem to really stop the mind and shock the mind as to there is a strong potential right of control that the franchisor can exercise over the franchise.
Counsel, let me fast forward quickly to the contract between your clients and Country Club Homes. There was a written contract, correct?
Correct.
And there's a provision in that contract under the heading acknowledgement of guarantees and disclaimers that your clients sign off on initially, correct?
Correct.
I understand that ARA, Arthur Ruttenberg Homes, is a trademark only and is being used by Builder Country Club Homes and by ARA, and that neither ARA personally nor Arthur Ruttenberg has any legal involvement in or responsibility, obligation, or liability for the construction of my home. Your client signed it, correct?
Correct.
How does that not win the day for the appellees?
Well, as a preliminary matter, this is still considered not only Country Club Homes, the contracting party is relieved of liability, but whether the franchisor is relieved of liability. And since exculpatory clauses are creatures of contract, they can only benefit from its protection if it is either a party to the contract, which is irrefutably is not, or if it's an intended third-party beneficiary. Now, as a preliminary point, of course, this was not, we can see it was not permitted an appeal. However, the trial court never at any point also made a determination on this matter.
Let me ask you about what you just said. Is this an exculpatory clause? I've dealt with a lot of them. This doesn't have that feel to me. Classic an exculpatory clause is you go into some sort of facility, perhaps, and I'm going to hold you harmless. I'm not going to sue you if something bad happens related to your negligence. I don't see that as being this. This looks like an outlining of what the relationships are between ARH and Country Club Homes. So if it's not an exculpatory clause, wouldn't we just look at the language of the agreement?
Correct, Your Honor. That was the argument we posed at the trial level, where this seems more of a memorandum of understanding as to what role any Arthur Ruttenberg would have in the construction or negotiation of the contract itself. And so we believe it is not an exculpatory clause at all. And to the extent in which this court decides to interpret it as such, we nonetheless believe it is unenforceable as a matter of public policy, and because it does not meet the requisite standard as set by this court's.
Let me ask you about public policy. What is difficult to understand about this provision? I mean, because that's one of the factors. I mean, you have to have something that's obtuse, something out of the ordinary, something that is forcing one of the sides, perhaps, who's not savvy in that type of thing, to be unable to understand. So help me understand what's not clear about this provision.
Sure. So if we were to look at prior precedents, whether it's the Brooks decision, the Hackett decision, the Lowe's decision, and many others have been cited by the parties' briefs, one common thread that we see is that there is contractual getting away language. I hereby understand that I relieve this company and its officers and officials of liability with regards to this specified amount of situations or circumstances. There is no such language here. It simply says that Arthur Weatherford has no responsibility, obligation, or liability. And since the Perkins standard, as Your Honor has just hinted, is an ordinary vulnerable person standard, specifically the standard as set by the Samuel Florida Supreme Court decision, is whether the language is unambiguously clear and understandable. That the franchise in this case, we believe the liability is such that ordinary vulnerable persons can understand. This language, again, is read more like a memorandum of understanding. And to further tie it to the Tappan case that was decided by this court several years ago, if there is the possibility of very reasonable interpretations, that is sufficient for there to be proof of insufficient specificity for the contract to be enforced.
What is another interpretation of this, other than they're not involved, so they're not liable?
Well, like Judge Jay just pointed out, this seems less akin to a typical exculpatory clause and more of a memorandum of understanding, stating that you as a home purchaser understand that Arthur Weatherford has no involvement in the contract or the construction of the property. That's another alternative reasonable interpretation, and as such, it will not be enforceable for that reason alone. And I would like to reserve the rest of my time for rebuttal.
All right, counsel, thank you very much. Yes, ma'am.
Good afternoon, may I support? My name is Jessica Mazariga, and I represent the police, our representatives. I'd like to start to address the court's question, specifically, Judge Jay, you specifically noted our question, my colleague across the aisle, about actual agency theory. And I would ask the panel to focus on those two elements because the prior court case law specifically says that actual agency hinges on the first two elements being found on the record before you move on to the aspect of control. The first two aspects, or the first two elements, are the acknowledgement by the principal that the agent were to act as a principal's agent. The second element would be that the agent undertook or accepted that agency role. The record is completely devoid of any evidence that reflects that those two elements actually occurred in this case. And Judge Lane, I want to point out that you correctly cited this record and correctly questioned my colleague about the franchise agreement, the very standard franchise agreement in this case. The case law is very clear that as a bedrock of the franchise industry, there has to be some sort of control. There has to be some sort of preservation of that brand quality, and that's what the franchise agreement does. And that's what our argument is about.
Counsel, the franchise and license agreement, and under the heading of relationship of the parties, which I just asked counsel, the parties believe that this relationship is independent contract, not agent, not a joint agency, not a joint venture, not a partnership. Is that possible?
It is. You say it's the best evidence of the parties' intentions, Your Honor. And I do believe that it's the best evidence in order to become or make a determination that it is dispositive in this case. Now, we understand that the case law says you can look to act outside of the contract. However, the record is void in this case that Reverend Holmes ever operated, ever exercised any control over the franchisee, Country Club Homes, in this case. So we ask the court to look at the words, because words matter in this case. And not only does the trial court have the luxury in a franchise case, so not only look at the franchise agreement, but also the building agreement. And both clarify that there is no agency.
Is it undisputed in this record, and perhaps the Collins Council has already conceded this, is it completely undisputed, unequivocal, that ARH played no role in the building of this house?
That is in the record, Your Honor, and it's undisputed that Arthur Homes played no role in the development of the construction of the home, and that is what's on appeal, is the construction of the actual home.
I mean, from the breaking ground all the way to final product. ARH is not involved. There's nothing in this record anywhere showing ARH is involved in supervision, work on the house, oversight, calls with contractors, independent contractors. Nothing like that in the record.
That is absolutely correct, Your Honor. In fact, we have multiple depositions where the subcontractors, the principals of Country Club Homes, all indicated that they had no contact with Arthur Homes. No one was on site. In fact, Ms. Messer and Mr. Messer both testified under oath in their deposition as well, stating that no representative was on site from Arthur Homes. So the record is completely devoid that Arthur Homes ever actually visited the site, ever engaged in any sort of construction or supervision, and it's a legal impossibility that they could, because Arthur, they're not a builder, they're not a contractor, they're a franchisor. They're not licensed in Florida. They're just simply a franchisor that designs and trademarks their layouts in their floor plans, and that is the sole aspect and function of Arthur Homes, is to develop that quality floor plan that is recognizable in the industry.
Well, the council brought up this intermeeting related to plans. Is that a feature of our evaluation of this case?
No, Your Honor, and I would just like to elaborate on that aspect and that factor for the court's consideration. Mr. Messer is actually a very sophisticated individual. It includes Mrs. Messer. She's a teacher of many, many years in advanced subjects. And then Mr. Messer has actually been in the industry of franchising and licensing, brand quality, Disney, Fortune 500, Fortune 100 meetings. And so he is fully aware of the licensing and the branding requirements. He went into business with Country Club Homes prior to purchasing this home. And he was a partner with the franchisee in the construction. He had not only insider knowledge of the operations of the contractor itself, but he also purchased from them as well. And so there's this whole duality argument that my colleague Ms. Isle has presented, that the language is not clear and unequivocal to an ordinary person, and an ordinary person would have the knowledge to understand the language. However, Mr. and Mrs. Messer clearly, of course, did, because they were sophisticated consumers, which is addressed in the LA Supreme Court case, the Norris case as well, saying that you're sophisticated. You can't ignore the fact that you're a sophisticated consumer in recognizing the fact that you understood the operation, you can clearly understand and read the language of the contract. Now, the social meeting itself is what was conceded by my colleague. It was just a social meeting. There were no discussions regarding the actual construction, and it definitely does not rise to the level of agency by simply having dinner and drinks with the principal of the company.
Was Country Club Homes free to deviate from the prints and plans of the homes they built, that the plans were received from ARH?
Absolutely, and it was actually a necessity that they had to deviate from it. And I'll give you an example, Judge. In the construction manual, that was the tolerance manual that was presented and drafted by Arthur Homes, granted it is an okay document. The manual itself does not address curb straps. Yet, Florida law clearly requires curb strap air conditioning units in order to protect the structural costs. The general contractor signs permits and licenses under the state of Florida in order to control construction means and methods in order to build each project and each home property, which of course is recognized by Florida law. Each property is a unique real property that must be considered independent from others. Now, the franchise agreement in the record also reflects that franchisees had full discretion and autonomy in order to choose any subcontractors it desired. It had an option, if it wanted to, consult for a fee for service outside of the franchise agreement, but a fee for service the architect was designed in order to design any floor plans, and that's exactly what happened in this case. The designer was retained, paid for service outside of the four corners of the contract in order to help Mr. Messer's request satisfying Mr. Messer's request to meld two trademark floor plans together. That design assistant helped Mr. Messer accomplish that goal. And in that original design, which I want to make clear for the court, there are no allegations of design defects. This is just simply a construction plan, and it just related to the construction of the home. Now, the design aspects of the design work had no style, which is the basis of this complaint, had no style in the design. In fact, later on, Mr. Messer, actually, Mrs. Messer, submitted a change order request to change the original design in order to add the stairwell to the attic. For some reason or another, that scuttle eventually appeared and allegedly led to Mrs. Messer's injuries. But the original design and the original, it was changed by Mr. Messer, and throughout the entire course of Country Club Homes operations, the Country Club Homes had the option to choose any vendor it desired. It did not have to work for homes. I like to make that clear for address. Moving on to the, going back to the actual agency theory, which is up on appeal, the trial court did rule in favor of the franchisor of Country Homes as to having no apparent agency. We're only here on actual agency. We'd ask the court focus on the first two elements, but if we move on to the third element, which is the control aspect, as my colleague from the aisle did delineate quite a few examples of the record of alleged control. However, perceived control. However, we're not here on reliances, we're here on the right to retain that control. And the right to retain control is completely devoid of the record. And I would like the court to focus on the fact that the case law says that there has to be substantial control to establish the Supreme Court Noble case over the day-to-day operations. That day-to-day operations is reflected in the Ferrer case, in the Ortega case, the Farr case. It is all across the entire state. But the day-to-day operations have to be effective and controlled and managed by a franchisor in order to establish that third element, regardless of the first two elements. The third element of control, we look at the contract itself, which is the best evidence of the intention of the parties. We look at the franchise agreement, which specifically says you are not an agent. We look at the billing agreement, which was signed and initialed by both parties, or by all parties, I apologize, Mr. and Mrs. Messer and Country Homes, that this is a disclaimer that Mr. and Mrs. Messer understood that there was no legal involvement by our
What about the exculpatory clause? First question, is this an exculpatory clause?
Yes, Your Honor. So it is not an exculpatory clause. We believe it is not an exculpatory clause based on the general rule. The general rule for exculpatory clauses is that it must be a party to the contract, which Country Homes is not a party to the contract. However, the exception to that rule is a third-party beneficiary under the contract. And that exception to the rule was waived, the third-party beneficiary was actually waived by my colleague's file at the lower court level. So that cannot be raised for the first time, as Judge Levine has addressed in several other prior oral arguments. That did not be raised for the first time here before you today.
So it would be your position that ARH was a third-party beneficiary of this agreement between appellants and Country Club Homes?
That is the closest it comes that this clause comes to fit within the label of an exculpatory clause. The trial attorney did not label it an exculpatory clause. It was actually the plaintiff's counsel or appellant's counsel at the trial court level that labeled it an exculpatory clause and then said, oh, it's not enforceable. We disagree. We believe that the heading in the caption, which is the acknowledgement and disclaimer, is the best description of that clause. And there's no heading or captions clause in this agreement that says we have to disregard headings and captions. So we believe that's the best description as set in the
acknowledgement of guarantees and disclaimers.
Yes.
Does that come today by itself? That's an acknowledgement of guarantees and disclaimers.
Absolutely, because we're together. That in itself was signed and initialed by the parties, and just taking the plain language, which in the San Diego case said that as long as you put liability in that clause, then liability is clearer language than negligence. We have no liability in our case, Your Honor. So we ask the court honor that as a clear designation of the intention of the parties. And
so that would be the language, A or H does not have any legal involvement in or responsibility, obligation, or liability.
Absolutely, Your Honor. That wins the day on its own, and that's our position. That wins the day on its own. But if the court would like to look further, then look further into the background of this semester, being a very sophisticated licensing and branding individual in the industry for decades. He's also in partnership with Country Club Homes, so he's fully aware of the franchiser not everything on site with the franchise builds, and look further too as well back to the franchise agreement. Mr. Messer, of course, had actual knowledge of being in partnership with the franchisee. And
Good, thank you. Council brought up that it's their position this is a memorandum of understanding. Does that change the paradigm?
It's however you want to label it, Your Honor. The words of the actual document and the contract itself don't change. And if you want to put anything on it, I would ask the court honor the original heading caption as a disclaimer, where the Messers disclaimed or said that I understand there is no claim of liability against Parker Member Homes.
And my question is a tad more specific than that. If it is what council's saying, a memorandum of understanding, does that make this a bad question for the jury, or is it still something as a memorandum of understanding that the court could find as a matter of law would eliminate their ability to advance this claim?
So memorandum of understanding has a little bit of an artful meaning to it, so I would back away from labeling it a memorandum of understanding. The memorandum of understanding doesn't respect the fact that there's a binding contract between the parties. Memorandum of understanding can be a letter of intent that can predate a contract or otherwise. It can be signed, it cannot be signed. We ask the court refer to this as a contractual clause acknowledging the fact that Mr. and Mrs. Messer acknowledge and understand, which is an element of exculpatory clause, that the party must have knowledge of what they're giving away. They signed an initial saying, I understand there is no claim against Parker Homes for liability regarding the construction of a home, and that they're not involved in any way. And then the record supports that clause as well, that there was no involvement. It's just the actual involvement was devoid of record. Going back to the public policy point that Your Honor did bring up, I want to emphasize that public policy does disfavor exculpatory clauses. However, exculpatory clauses, or that public policy is based on the fact that that one of the parties is trying to shift the liability of their own negligence. That is different in this case. Our home did not shift its liability. They're saying it did not have involvement. The record does support that there was no involvement as well. So we would ask that there is a distinction as well. Furthermore, the language is very clearly understandable. It's been upheld by Ilgen, it's been upheld by Norris, and Norris is the exact language. Ilgen is a little slightly different, but it was the same party involved in similar contract, just earlier version of the contract. But there is precedent, there is case law that upholds the franchise agreement and building agreement, stating that there is no agency. But that is the exculpatory clause finding by the trial court was actually an alternative finding. The original finding, the main reason why we're here today, Your Honors, is the fact that there was no finding of actual agency. The appellants brought up a fundamental error issue. We asked the court to disregard that as one argument in the and they were definitely not denied due process. This is a 6-year-old case, they amended the complaint 4 or 5 times, they had multiple bites in the apple, extensive discovery, they had several chances in order to complete their cause of actions, in order to discover any evidence. They couldn't discover any evidence, it didn't exist, the record was devoid of anything that would support, genuinely support a material dispute of the facts, genuinely support an alternative finding that the trial court would find ultimately. And I would ask the court to focus on the original 2 elements of that actual agency. Furthermore, the use of the trademarks and the logos and the advertisements and the bookkeeping methods, the courts have amply gone through all of those factors and have said that none of those are dispositive. In fact, that in order to render Arthur Emmerich Holmes Country Club Homes an agent of Arthur Emmerich Holmes. So we'd ask the court not focus on these slight little facts throughout the entire record, but in fact the entire record as a whole. And the entire record as a whole shows the multiple depositions and the language itself is the best evidence before the court that that Country Club Homes was not an agent and never was an agent, and in fact never actually was an agent of Arthur Emmerich Holmes, and Arthur Emmerich Holmes never exercised control or retained the control over Country Club Homes as well. And that goes to the licensing issue that Robert brought up, that Country Club Homes is the licensed contractor in the state of Florida. Arthur Emmerich Holmes is not. The construction manual does lay out some standardizations, but it is not a heritage Bible, as Domino's Pizza Case says. The construction manual simply says, here are the standards we're looking for, here are the best practices we're looking for. Of course we don't want Chinese drywall in any home. That's just a matter of safety at this point. That's not evidence of control.
I just want to stop you before you run out of time here. You mentioned that essentially the disclaimer and exculpatory clause is an alternative argument, essentially an alternative ground for the court. And you mentioned in your brief Applegate and its use in a motion for summary judgment. Now, our court, as well as all the other DCAs, aside from the 6th DCA, and the Florida Supreme Court have ruled that Applegate or the tipsy coachman doctrine, however you want to put it, is not applicable in motions for summary judgment at this stage. So, how do you feel about that now? We're under a different standard. A lot of these cases, a lot of these franchise agreement cases are old. The standard has changed. We've now adopted the federal standard, which does allow the tipsy coachman doctrine to apply in motions for summary judgment. Are you making that argument here, or what is your position on that?
Yes, I think you're bringing that up. The court can affirm the trial court's ruling on any basis found in the record, and we ask the court to recognize that in the tipsy coachman doctrine. And just from a timing perspective, the first initial order came out in March of 2020 and 2021, but I think we got 18 months apart from the second order. And during those 18 months is when the standard changed. And the order came out in November of 2022, which was after the standard change. So we would ask this court honor that and affirm the lower court's decision. No further questions?
Thank you, counsel, for your
Thank you very much. Thank you very much.
Thank you. Counsel, you have 4 minutes and 1 second remaining for your rebuttal.
Thank you, Your Honor. I'm going to respond in reverse order based on my colleague's responses and her opening remarks. Regarding the exculpatory clause in question, she made emphasis that appellate briefs makes mention of appellant sophistication construction management. That is no bearing in this matter because the standard in Florida is ordinary and honorable person standard. She also claimed that the use of the term liability is dispositive of the issue of whether a contract is enforceable. However, I would direct your court's attention to the 5th DCA ruling in Tappan in 2009, where language in dispute stated, I agree to not hold SCKC or Brevard County Parks and Recreation Department liable for any accident or injury. The court nonetheless found this clause to be too ambiguous because it did not clearly define the types of injuries that were covered in the circumstances, and we believe that is also analogous in this matter. And counsel also mentioned the Norris case, which is an Arthur Lundenberg case in the Supreme Court of Alabama, which had a very similar exculpatory clause that was approved. However, that court had a different standard in Florida. There they specifically focused on the subjective knowledge of the plaintiff, who was a sophisticated doctor with extensive experience in the construction industry, and dedicated sufficient argumentation on that end. So that is very distinguishable as a completely different standard is not applicable to Florida. As to the question of the third-party beneficiary status, again, as we've already believe on the fundamental error, this issue should still be heard, especially on the merits. And to the merits of the question, Appellee's brief states that the contract in itself, which was a boilerplate language provided by Arthur Wood Firms, somehow in and of itself provides sufficient evidence that Country Club and Appellant's Audrey Allen Messer had the intent to primarily and directly benefit the franchisor. The contract does not speak to that. Arthur Rutherford Homes Inc. is only mentioned once in this over 10-page document. We believe there's simply insufficient evidence on the record to satisfy the records standard. Now, as for the actual agency question, we just want to clarify that this is not a question of whether there was actual control by the franchisor, but whether there was a right of control, not whether they actually exercised the right of control. That was the test set by this court in the final decision. And again, we believe that there's more than ample evidence that's substantially understood as a material fact, such that a reasonable jury could rule in Appellant's favor. That is the important question here. It's not to trial the evidence in front of the appellate body, which is inappropriate in this juncture. And we would also clarify some of the characteristics of the franchise agreement presented by counsel. For example, she mentioned that the custom plans they don't have to comport with the custom plans or design plans by the franchisor, referring to the franchisee here. Quite the contrary, the franchise agreement states that they have to comport by Arthur Rutherford plans unless they go with CAD operator, a computer-aided developer from out of the franchisee who had to sign a confidentiality form that was provided exclusively by the franchisor. For the rest of the subcontractor, they did not have the right to choose whichever subcontractor they wanted. The franchise agreement provided specific insurance and licensure requirements that they had to comport with the terms of vendors. For example, there was a purchase order that was produced during discovery that claimed that you're not allowed to purchase Chinese driver, which is another further example of sufficient control by the franchisor or the franchisee that was emulated in practice. There's a lot of discussions been raised as to whether the franchisor is a licensed contractor and such to dictate the terms. But regardless of that question, in practice, Country Club actually followed through on this obligation of their franchise agreement. The construction manual that outlines every phase of construction from the foundation to the roofing to the framing, it says they have to comply with it. And that failure to comply will allow the franchise to terminate the agreement. And as evidenced by subcontractors and framers that had their positions taken, there was clear evidence that Country Club had complied and comported with the requirements of the construction manual, which defined the day-to-day operations of the company as a residential developer in Flagler County. And as such, we respectfully request that this court reverse the trial court's decision and amend the proceedings. Thank you.
Counsel, thank you all for your capable arguments. That concludes the final case set for oral argument. The court would like to express its gratitude to Jacksonville University, to President Cost, to Dean Allard for their hospitality in hosting the court session today. And with that, we stand in recess.
All right.